4 of 2001, binding upon their agencies and institutions, and upon the communities and citizens of their areas. Power to raise revenue. 76. Parliament may provide for regional democratic councils to raise their own revenues and to dispose of them for the benefit and welfare of their areas. 77. The development program of each region shall be integrated into the national development plans, and the government shall allocate funds to each region to enable it to implement its development program. Regional development program to be integrated into the national development plans. Parliament to provide criteria for allocation of resources by local democratic organs. 4 of 2001. 77A. Parliament shall by law provide for the formulation and implementation of objective criteria for the purpose of the allocation of resources to, and the garnering of resources by local democratic organs. Local government elections. Parliament may make provision for the election of members of local democratic organs, including the commencement of balloting before the day appointed for holding an election, and for all other matters relating to their membership, powers, duties, functions, and responsibilities. Local Government Commission. 4 of 2001, 78A. Parliament shall establish a local government commission, the composition and rules of which empower the commission to deal with, as it deems fit, all matters related to the regulation and staffing of local government organs, and with dispute resolution within and between local government organs. Representativeness and accountability of local democratic organs to the electorate. 4 of 2001, 78 billions. The electoral system in respect of local democratic organs below the regional democratic councils shall provide for the involvement and representation of individuals and voluntary groups, in addition to political parties, and accountability to the electors. 79 to 81. Article 79 to 88, repealed by Act No. 14 of 2000. 82 to 88. Chapter 7th, Articles 82 to 88, Chapter 9, the President. Establishment of Office of President. 89. There shall be a President of the Cooperative Republic of Guyana, who shall be head of state, the supreme executive authority, and commander-in-chief of the armed forces of the Republic. Qualifications for election. August 17, 2000. 90. 1. A person shall be qualified for election as president, and shall not be so qualified unless he or she, a. is a citizen of Guyana, and is Guyanese by birth or parentage as defined in Articles 43 and 44. B. is residing in Guyana on the date of nomination for election, and was continuously residing therein for a period of 7 years immediately before that date, and C. is otherwise qualified to be elected as a member of the National Assembly. 2. A person elected as president after the year 2000 is eligible for re-election only once. 3. A person who acceded to the presidency after the year 2000 and served therein on a single occasion for not less than such period as may be determined by the National Assembly, is eligible for election as president only once. 4. In determining continuity of residence, absence from Guyana to a. seek medical help, b. study at a university or an institution of higher learning for not more than 4 years, c. work for the government, shall be disregarded. 91. The President shall be elected by the people in the manner prescribed by Article 177. Tenure of Office of President. 92. A person assuming the office of President in accordance with the provisions of this Constitution shall, unless his or her office sooner becomes vacant under Article 178, continue in office until the person elected to the office of President at the next election, held under Article 91, assumes office. 93. The President may be removed from office if he or she becomes physically or mentally incapable of discharging the functions of his or her office. The procedure for removing him or her and for ensuring the continued discharge of the functions of his or her office is prescribed by Article 179. Removal of President. For 94. The President may be removed from office if he or she commits any violation of this Constitution or violation of Constitution or gross misconduct. Vacancy in office of President. Any gross misconduct. The procedure for removing him or her is prescribed by Article 180. 95. 1. During any period when the office of President is vacant, the office shall be assumed by a. the Prime Minister, provided that if the vacancy occurs while the Prime Minister is absent from Guyana, or while he or she is by reason of physical or mental infirmity unable to perform the functions of his or her office, the functions of the office of President shall, until the Prime Minister returns or until he or she is again able to perform the functions of his or her office as the case may be discharged by such other minister, being an elected member of the National Assembly, as the Cabinet shall elect, or b. if there is no Prime Minister, by such minister being an elected member of the National Assembly, as the Cabinet shall elect, or c. if there is no Prime Minister and no Cabinet, by the Chancellor. 2. Minister performing the functions of the office of President by virtue of the proviso to paragraph 1a shall cease to perform those functions if he or she is notified by the Prime Minister that the Prime Minister is about to assume the office of President. 3. An assumption of the office of President under this article shall terminate, if it has not previously terminated, when a person who has been elected to the office in accordance with the provisions of Article 177 assumes the office. Discharge of functions of President during absence, illness, etc. 96. 1. Whenever the President is absent from Guyana or considers it desirable so to do by reason of illness or any other cause, he or she may, by direction in writing, authorize any member of the Cabinet, being an elected member of the National Assembly, to perform such of the functions of the office of President as he or she may specify, and the person so authorized shall perform those functions until his or her authority is revoked by the President, or until the functions are resumed by the President. 2. If the President is incapable by reason of physical or mental infirmity of discharging the functions of his or her office, and the infirmity is of such a nature that the President is unable to authorize another person under this article to perform those functions, A. The Prime Minister, or B. During any period when there is no Prime Minister or the Prime Minister is absent from Guyana or is, by reason of physical or mental infirmity, unable to perform the functions of his or her office, such other minister, being an elected member of the National Assembly, as the Cabinet shall elect, or C. If there is no Prime Minister and no Cabinet, the Chancellor shall perform the functions of the office of President, provided that any person performing the functions of the office of President under this paragraph shall not dissolve Parliament nor, save on the advice of the Cabinet, revoke any appointment made by the President. 3. Any person performing the functions of the office of President by virtue of paragraph 2 shall cease to perform those functions if he or she is notified by the President that the President is about to resume those functions. Oath to be taken by President. A person elected as President shall assume the office of President upon being elected, but shall, before entering upon the duties of the office, take and subscribe the oath of office, such oath being administered by the Chancellor or such other judge of the Supreme Court of Judicature, as may be designated by the Chancellor. 2. The provisions of the foregoing paragraph shall apply to any person assuming the office of President, or performing the functions thereof under Article 95, 96, or 179, as the case may be, as they apply to a person elected as President. Remuneration, etc. of President. 98. The remuneration and immunities of the President shall be regulated by Articles 181, 182, and 222. Chapter 10. The Executive Authority of Guyana. 99. 1. The executive authority of Guyana shall be vested in the President, and subject to the provisions of this Constitution, may be exercised by him or her, either directly or through officers subordinate to him or her. 2. Nothing in this article shall prevent Parliament from conferring functions on persons or authorities other than the President, establishment of office of Prime Minister and other ministerial offices. 100%. Subject to the provisions of Article 185, there shall be an office of Prime Minister and such offices of Vice President and other offices of Minister of the Government of Guyana, as may be established by Parliament, or, subject to the provisions of any Act of Parliament, by the President. The Prime Minister. August 17, 2000. 101. 1. The President shall appoint an elected member of the National Assembly to be Prime Minister of Guyana, provided that a person who is not eligible to be elected as President shall not be eligible for appointment as Prime Minister. 2. The Prime Minister shall be the principal assistant of the President in the discharge of his or her executive functions and leader of government business in the National Assembly. Vice Presidents. 102. 1. The President may appoint Vice Presidents for the purpose of assisting him or her in the discharge of his or her functions. 2. If he or she is not otherwise the holder of an office of Vice President, the person holding the office of Prime Minister shall, by virtue of holding that office, be a Vice President, and he or she shall have precedence over any other Vice President. Ministers. August 17, 2000. 103. 1. The Prime Minister and every other Vice President shall be a Minister of the Government of Guyana. 2. Subject to the provisions of Article 101(1), Vice Presidents and other ministers shall be appointed by the President from among persons who are elected members of the National Assembly, or subject to subparagraph 7 of paragraph 3A of Article 160, are qualified to be elected as such members. 3. Not more than 4 ministers and 2 parliamentary secretaries shall be appointed by the President from among persons who are qualified to be elected as members of the National Assembly. Ministerial appointments during dissolution. August 14, 2000. 104. Articles 101(1) and 103(2) shall have effect in relation to any period between a dissolution of Parliament and the day on which the next election of members of the Assembly is held pursuant to the provisions of Article 61, as if Parliament had not been dissolved. 105. A minister who was not an elected member of the Assembly at the time of his or her appointment shall, unless he or she becomes such a member, be a member of the Assembly by virtue of holding the office of minister, but shall not vote in the Assembly. 106. 1. There shall be a cabinet for Guyana, which shall consist of the President, the Prime Minister, the Vice Presidents, and such other ministers as may be appointed to it by the President. 2. The cabinet shall aid and advise the President in the general direction and control of the government of Guyana, and shall be collectively responsible therefore to Parliament. 3. Cabinet meetings shall be presided over by A. The President, B. In the absence of the President, the Prime Minister, or C. In the absence of the President and the Prime Minister, such minister as the President may designate. 4. The Cabinet may act notwithstanding any vacancy in its membership or the absence of any member thereof. 5. At the invitation of the President or of any person presiding at a meeting of the Cabinet, a minister who is not a member of the Cabinet may attend that meeting and participate fully in the proceedings, as if he or she were a member. 6. The Cabinet, including the President, shall resign if the government is defeated by the vote of a majority of all the elected members of the National Assembly on a vote of confidence. 7. Notwithstanding its defeat, the government shall remain in office and shall hold an election within 3 months or such longer period as the National Assembly shall by resolution supported by not less than 2/3 of the votes of all the elected members of the National Assembly determine, and shall resign after the President takes the oath of office following the election. Allocation of portfolios. August 17, 2107, the President may assign to any minister responsibility for any business of the Government of Guyana, including the administration of any department of government, and shall be charged with all responsibility not assigned to any minister. In respect of responsibility so charged, the President shall appoint a minister or parliamentary secretary to be answerable to the National Assembly, therefore, on his or her behalf, provided that authority to exercise any power or discharge any duty that is conferred or imposed by any other provision of this Constitution, or by any other law on any person or authority, shall not be conferred under this article. Tenure of office of ministers. 108. The office of a minister shall become vacant in the circumstances set out in Article 183. Minister's absence or illness. 109. Whenever any minister is absent from Guyana or is unable by reason of illness to perform his or her functions as minister, the President may authorize some other minister to perform those functions, and that minister may perform those functions until they are resumed by the first mentioned minister or are assigned to another minister pursuant to the provisions of Article 107. Leader of the Opposition. 2 of 2000. 110. 1. There shall be an office of Leader of the Opposition, election to which office shall be in accordance with Article 184. 2. Qualifications for election to the office of Leader of the Opposition and other matters connected therewith are regulated by Article 184. Exercise of President's powers. 111. 1. In the exercise of his or her functions under this Constitution or any other law, the President shall act in accordance with his or her own deliberate judgment, except in cases where, by this Constitution or by any other law, he or she is required to act in accordance with the advice, or on the recommendation of any person or authority. 2. Where by this Constitution the President is directed to exercise any function on the advice or recommendation of any person or authority, he or she may, in accordance with his or her own deliberate judgment, once refer any such advice or recommendation back for reconsideration by the person or authority concerned, and if that person or authority, having reconsidered the original advice or recommendation, substitutes therefor a different advice or recommendation, as the case may be, the President shall act in accordance therewith, but save as aforesaid, he or she shall act in accordance with the original advice or recommendation. Attorney General. 112. 1. There shall be an Attorney General of Guyana, who shall be the principal legal advisor to the Government of Guyana, and who shall be appointed by the President. 2. Qualifications for appointment to the office of Attorney General and other matters connected therewith are regulated by Article 185. 113. 1. The President may appoint parliamentary secretaries to assist himself or herself or ministers in the discharge of their functions. 2. Qualifications for appointment to the office of parliamentary secretary and other matters connected therewith are regulated by Article 186. Oaths of ministers, etc., permanent secretaries, standing committees. 119. Subject to any provision made by Parliament, the President may appoint standing committees consisting of such persons as he or she may deem fit for the purpose of reviewing or examining any aspect of national life, and making recommendations or otherwise reporting thereon to the government or to Parliament. Parliamentary Standing Committee for Constitutional Reform. 8 of 2001. 119a. 1. The National Assembly shall establish a Parliamentary Standing Committee for Constitutional Reform for the purpose of continually reviewing the effectiveness of the working of the Constitution and making periodic reports thereon to the Assembly, with proposals for reform as necessary. 2. To assist it in its work, the committee shall have the power to co-opt experts, or enlist the aid of other persons of appropriate expertise, whether or not such experts or other persons are members of the Assembly. Parliamentary Sectoral Committees. 8 of 2001. 119 billions. 1. There shall be parliamentary sectoral committees established by the National Assembly with responsibility for the scrutiny of all areas of government policy and administration, including I. Natural resources, I. Economic services, I. Foreign relations, IV. Social services. 2. The chairperson and deputy chairperson of each parliamentary sectoral committee shall be elected from the opposite sides of the National Assembly. Standing Committee to address matters relating to appointment. 119 c. There shall be a Standing Committee of the National Assembly which shall have responsibility for initiating or otherwise taking such action, or addressing such matters as may be entrusted to the Committee by the National Assembly, in respect of functions required to be of members of commissions established under the Constitution. 8 of 2001, discharged by the Assembly, under the Constitution in relation to the appointment of a member of a commission, established under the Constitution. Parliamentary Oversight Committee on the Security Sector. 5 of 2009, Constitution of Offices. August 17, 2000. 119d. 1. There shall be a Standing Committee of the National Assembly to be named the Parliamentary Oversight Committee on the Security Sector, and it shall have responsibility for examining the policies and administration of the entities in the security sector, namely, the disciplined forces of Guyana. 2. To assist in its work, the committee shall have the power to co-opt experts or enlist the aid of other persons of appropriate expertise, whether or not such experts or persons are members of the National Assembly. 120. Subject to the provisions of this Constitution and of any other law, the President may constitute offices for Guyana, make and terminate appointments to such offices, save that where the constitution of, and making of appointments to, such offices involve expenditure chargeable to the Consolidated Fund, such expenditure shall be subject to the approval of the National Assembly. 121. The prerogative of mercy shall vest in the President, and shall be exercised by him or her in accordance with the provisions of Articles 188, 189 and 190. 122. 1. There shall be an Ombudsman for Guyana. 2. All matters relating to the appointment and functions of the Ombudsman and other matters connected therewith are regulated by Articles 191 to 196 inclusive. Chapter She the Judicature. The Supreme Court of Judicature, Independent Judiciary, 6 of 2001, 122, a. 1. All courts and all persons presiding over the court shall exercise their functions independently of the control and direction of any other person or authority, and shall be free and independent from political, executive and any other form of direction and control. 2. Subject to the provisions of Articles 199 and 201, all courts shall be administratively autonomous, and shall be funded by a direct charge upon the Consolidated Fund, and such courts shall operate in accordance with the principles of sound financial and administrative management. Establishment of Supreme Court of Judicature. 6 of 2001, 123. 1. There shall be for Guyana a Supreme Court of Judicature consisting of a Court of Appeal and a High Court, with such jurisdiction and powers as are conferred on those courts respectively by this Constitution or any other law. 2. Each of those courts shall be a superior court of record, and, save as otherwise provided by Parliament, shall have all the powers of such a court. 3. Parliament may confer on any court any part of the jurisdiction of, and any powers conferred on the High Court by this Constitution or any other law. 4. Parliament may make such provision as it deems fit authorizing any court established or to be established as the final court of appeal for the Caribbean to be the final court of appeal for Guyana. 5. Where a court referred to in paragraph 4 is established and becomes the final court of appeal for Guyana, such court shall remain the final court of appeal for Guyana unless Parliament, by a vote of no less than 2/3 of all the elected members of the Assembly, makes provision for Guyana to withdraw from such court. Constitution of High Court. 124. The judges of the Court of Appeal shall be the Chancellor, who shall be the President of the Court of Appeal, the Chief Justice, and such number of Justices of Appeal as may be prescribed by Parliament. Judges of the Supreme Court of Judicature. Appointment of Chancellor and Chief Justice. 6 of 2001, 126, except as otherwise expressly provided or required by the context. In this Constitution the word judge includes the Chancellor, the Chief Justice, a Justice of Appeal, a puisne judge and a part-time judge. 127. 1. The Chancellor and the Chief Justice shall each be appointed by the President, acting after obtaining the agreement of the Leader of the Opposition. 2. If the office of Chancellor or Chief Justice is vacant, or if the person holding the office of Chancellor is performing the functions of the office of President, or is for any other reason unable to perform the functions of his or her office, or if the person holding the office of Chief Justice is for any reason unable to perform the functions of his or her office, then, until a person has been appointed to and has assumed the functions of such office, or until the person holding such office has resumed those functions, as the case may be, those functions shall be performed by such other of the judges as shall be. Laws of Guyana. Appointment of Justices of Appeal and puisne judges. 6 of 2001, appointed by the President after meaningful consultation with the Leader of the Opposition. 128. 1. The judges, other than the Chancellor and the Chief Justice, shall be appointed by the President, who shall act in accordance with the advice of the Judicial Service Commission. 2. If a. The office of any judge is vacant, b. Any such judge is for any reason unable to perform the functions of his or her office, c. Any such judge is acting as Chancellor or Chief Justice, or a puisne judge is acting as a Justice of Appeal, or d. The Chancellor advises the President that the state of business of the Court of Appeal or the High Court so requires, The President shall act in accordance with the advice of the Judicial Service Commission and appoint a person to act in the office of Justice of Appeal or puisne judge, as the case may require. 3. The appointment of any person under the preceding paragraph to act in the office of a Justice of Appeal or puisne judge shall continue to have effect until it is revoked by the President, acting in accordance with the advice of the Judicial Service Commission. Appointment of part-time judges. 6 of 2001, 128A, 1. Part-time judges may be appointed by the President, who shall act in accordance with the advice of the Judicial Service Commission. 2. Parliament may by law determine the terms and conditions of appointment of part-time judges. 129. 1. A person shall not be qualified to be appointed to hold or to act in the office of a judge unless a. He or she is or has been a judge of a court having unlimited jurisdiction in civil and criminal matters in some part of the Commonwealth, or a court having jurisdiction in appeals from any such court, or b. He or she is qualified for admission as an attorney at law in Guyana and has been so qualified for such period as may be prescribed by Parliament. Attendance of additional judge in Court of Appeal and High Court. 2. Parliament may prescribe different periods under subparagraph B of the preceding paragraph in relation to the offices of the different judges mentioned in Article 126. 130. 1. Parliament may make provision for the exercise of a. the jurisdiction and powers of a Justice of Appeal by such puisne judge as may be requested by the Chancellor to sit as an additional Justice of Appeal at sittings of the Court of Appeal, and b. the jurisdiction and powers of a. puisne judge by such Justice of Appeal as may be requested by the Chancellor to sit as an additional puisne judge. 2. Article 132 shall not apply to a Justice of Appeal or a puisne judge in the carrying out by him or her of any function pursuant to paragraph 1. Tenure of office of judges, appeals on constitutional questions and fundamental rights, oaths of judges. 131. Judges shall have full security of office as provided for in Article 197. 132. A judge shall not enter upon the duties of his or her office unless he or she has taken and subscribed the oath of office. Appeals. 133. 1. An appeal to the Court of Appeal shall lie as of right from decisions of the High Court in the following cases, that is to say, a. Final decisions in any civil or criminal proceedings on questions as to the interpretation of this Constitution, and b. Final decisions given in exercise of the jurisdiction conferred on the High Court by Article 153, which relates to the enforcement of fundamental rights and freedoms. 2. Nothing in paragraph 1 shall apply to the matters for which provision is made by Article 163. Chapter 12. The Service Commissions. The Judicial Service Commission. 134. 1. There shall be a Judicial Service Commission for Guyana. 2. The composition and functions of the Judicial Service Commission are set out in Articles 198 and 199. The Public Service Commission. 135. 1. There shall be a Public Service Commission for Guyana. 2. The composition and functions of the Public Service Commission are set out in Articles 200 to 205 inclusive. The Teaching Service Commission. 136. 1. There shall be a Teaching Service Commission for Guyana. 2. The composition and functions of the Teaching Service Commission are set out in Articles 207, 208 and 209. The Police Service Commission. 137. 1. There shall be a Police Service Commission for Guyana. 2. The composition and functions of the Police Service Commission are set out in Articles 210, 211 and 212. Part 2. Specific Rules. Title 1. Protection of Fundamental Rights and Freedoms of the Individual. Protection of Right to Life. 10 of 2003, 138. 1. No person shall be deprived of his or her life intentionally save in execution of the sentence of a court in respect of an offense under the laws of Guyana, of which he or she has been convicted. 1a. No person who is under the age of 18 years at the time when he or she committed an offense, for which that person has pleaded or was found guilty, shall be subject to capital punishment for the commission of that offense. 2. Without prejudice to any liability for a contravention of any other law with respect to the use of force in such cases as are hereinafter mentioned. A person shall not be regarded as having been deprived of his or her life in contravention of this article, if he or she dies as the result of the use of force to such extent as is reasonably justifiable in the circumstances of the case. A. For the defense of any person from violence or for the defense of property. B. In order to effect a lawful arrest or to prevent the escape of a person lawfully detained. C. For the purpose of suppressing a riot, insurrection or mutiny or D. In order to prevent the commission by that person of a criminal offense. Or if he or she dies as the result of a lawful act of war. Protection of right to personal liberty. 10 of 2003, 139. 1. No person shall be deprived of his or her personal liberty, save as may be authorized by law in any of the following cases, that is to say, a. In execution of the sentence or order of a court, whether established for Guyana or some other country in respect of a criminal offense of which he or she has been convicted. B. In execution of an order of the High Court or the Court of Appeal, or such other court as may be prescribed by Parliament punishing him or her for contempt of any such court, or of another court or tribunal. C. In execution of the order of a court made to secure the fulfillment of an obligation imposed on him or her by law. D. For the purpose of bringing him or her before a court in execution of the order of a court. E. Upon reasonable suspicion of his or her having committed, or being about to commit, a criminal offense under the law of Guyana. F. In the case of a person who has not attained the age of 18 years, under the order of a court or with the consent of his or her parent or guardian, for the purpose of his or her education or welfare. G. For the purpose of preventing the spread of an infectious or contagious disease. H. In the case of a person who is, or is reasonably suspected to be, of unsound mind, addicted to drugs or alcohol, or a vagrant, for the purpose of his or her care or treatment or the protection of the community. I. For the purpose of preventing the unlawful entry of that person into Guyana, or for the purpose of effecting the expulsion, extradition, or other lawful removal of that person from Guyana, or for the purpose of restricting that person while he or she is being conveyed through Guyana, in the course of his or her extradition or removal as a convicted prisoner from one country to another. J. To such extent as may be necessary in the execution of a lawful order requiring that person to remain within a specified area within Guyana, or prohibiting him or her from being within such an area, or to such extent as may be reasonably justifiable for the taking of proceedings against that person, with a view to the making of any such order or relating to such an order after it has been made, or to such extent as may be reasonably justifiable for restraining that person during any visit that he or she is permitted to make to any part of Guyana in which, in consequence of any such order, his or her presence would otherwise be unlawful. K. Subject to the provisions of the next following paragraph, for the purposes of his or her preventive detention. L. For the purpose of his or her being called up for national service. 2. A. No law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months, unless a tribunal established, for the purposes of this paragraph, has reported before the expiration of the said period of 3 months, that there is, in its opinion, sufficient cause for such detention. B. The references in subparagraph A to a period of 3 months include references to any lesser periods that amount in the aggregate to 3 months, provided that no two such lesser periods shall be aggregated for this purpose if the period between the expiration of the first and the commencement of the second is more than 1 month. C. A person who has been detained by virtue of the provisions of any law providing for preventive detention, and who has been released from detention in consequence of a report of a tribunal established for the purposes of this paragraph, that there is, in its opinion, insufficient cause for his or her detention, shall not be again detained by virtue of such provisions within the period of 6 months from his or her release on the same grounds as he or she was originally detained. D. For the purposes of subparagraph C, a person shall be deemed to have been detained on the same grounds as he or she was originally detained, unless a tribunal established as aforesaid has reported that, in its opinion, there appear prima facie to be new and reasonable grounds for the detention, but the giving of any such report shall be without prejudice to the provisions of subparagraph A. A tribunal established for the purposes of this paragraph shall be established by law and shall consist of persons who are judges of the laws of Guyana, Supreme Court of Judicature, or who are qualified to be appointed as puisne judges of the High Court. 3. Any person who is arrested or detained shall be informed as soon as reasonably practicable, in a language that he or she understands, of the reasons for his or her arrest or detention, and shall be permitted, at his or her own expense, to retain and instruct, without delay, a legal advisor of his or her own choice, being a person entitled to practice in Guyana as an attorney at law, and to hold communication with him or her. 4. Any person who is arrested or detained, A. For the purpose of bringing him or her before a court in execution of the order of a court, or B. Upon reasonable suspicion of his or her having committed or being about to commit a criminal offense, and who is not released, shall be brought before a court within 72 hours of arrest or detention, but the police may apply to the High Court for extensions of time, and if any person arrested or detained upon reasonable suspicion of his or her having committed or being about to commit a criminal offense, is not tried within a reasonable time, then without prejudice to any further proceedings which may be brought against him or her, he or she shall be released either unconditionally or upon reasonable conditions, including in particular such conditions as are reasonably necessary to ensure that he or she appears at a later date for trial or for proceedings preliminary to trial. 5. Any person who is unlawfully arrested or detained by any other person shall be entitled to compensation therefor from that other person. 6. Nothing in the provisions of paragraphs 3 and 4 shall apply to any person arrested or detained by virtue of the provisions of any law providing for preventive detention, except in so far as the provisions of the said paragraph 3 require that he or she shall be permitted to retain and instruct a legal advisor, and to hold communication with him or her. Protection from slavery and forced labor. 140. 1. No person shall be held in slavery or servitude. 2. No person shall be required to perform forced labor. 3. For the purposes of this article, the expression forced labor does not include A. Any labor required in consequence of the sentence or order of a court. B. Any labor required of any person while he or she is lawfully detained that, though not required in consequence of the sentence or order of a court, is reasonably necessary in the interest of hygiene or for the maintenance of the place at which he or she is detained. C. Any labor required of a member of a disciplined force in pursuance of his or her duties as such, or in the case of a person who has conscientious objections to service as laws of Guyana. A member of a naval, military, or air force, any labor that person is required by law to perform in place of such service, or D. Any labor required during any period when Guyana is at war, or in the event of any hurricane, earthquake, flood, fire, or other like calamity that threatens the life or well-being of the community, to the extent that the requiring of such labor is reasonably justifiable. In the circumstances of any situation arising or existing during that period, or as a result of that calamity, for the purpose of dealing with that situation. Protection from inhuman treatment, protection from deprivation of property. 9 of 1984, 1 of 1988, August 23, 1990, 10 of 2003. 141. 1. No person shall be subjected to torture, or to inhuman or degrading punishment or other treatment. 2. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article, to the extent that the law in question authorizes the infliction of any punishment, or the administration of any treatment that was lawful in Guyana, immediately before the commencement of this Constitution. 142. 1. No property of any description shall be compulsorily taken possession of, and no interest in or right over property of any description shall be compulsorily acquired, except by or under the authority of a written law, and where provision applying to that taking of possession or acquisition is made by a written law, requiring the prompt payment of adequate compensation. 2. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of the preceding paragraph. A. To the extent that the law in question makes provision for the taking of possession or acquisition of any property. I. In satisfaction of any tax, duty, rate, cess, or other impost. I. By way of penalty for breach of the law, whether under civil process or after conviction of a criminal offense under the law of Guyana. Key. As an incident of a lease, tenancy, mortgage, charge, bill of sale, pledge, contract, grant, permission, or license. IV. In the execution of judgments or orders of a court in proceedings for the determination of civil rights or obligations. V. In circumstances where it is reasonably necessary so to do, because the property is in a dangerous state or injurious to the health of human beings, animals, or plants. Vi. In consequence of any law with respect to the limitation of actions. Vescent. For so long only as may be necessary for the purposes of any examination, investigation, trial, or inquiry, or, in the case of land, for the purposes of the carrying out thereon of work of soil conservation, or the conservation of other natural resources, or work relating to agricultural development or improvement, which is not beneficially occupied, or which, if it is beneficially occupied, is not so occupied by the holder of the title to the land, or by any member of his or her family, or X. In consequence of any law requiring an employer to remunerate his or her employee during any period of compulsory national service, which the employee has undertaken, or B. To the extent that the law in question makes provision for the taking of possession or acquisition of I. Property of the Amerindians of Guyana for the purpose of its care, protection, and management, or any right, title, or interest held by any person in or over any lands situate in an Amerindian district, area, or village, established under the Amerindian Act for the purpose of effecting the termination or transfer thereof for the benefit of an Amerindian community. Key. Enemy property. He. Property of a deceased person, a person of unsound mind, or a person who has not attained the age of 18 years, for the purpose of its administration for the benefit of the persons entitled to the beneficial interest therein. IV. Property of a person adjudged insolvent or a body corporate in liquidation, for the purpose of its administration for the benefit of the creditors of the insolvent person or body corporate, and, subject thereto, for the benefit of other persons entitled to the beneficial interest in the property. A V. Property subject to a trust, for the purpose of vesting the property in persons appointed as trustees under the instrument creating the trust, or by a court, or by order of a court, for the purpose of giving effect to the trust, or by property to be used by the state for the purpose of providing, maintaining, and managing any place of education where the property was being used as a place of education at any time during 1976 and prior to the coming into operation of the law in question. 3. Nothing in this article shall be construed as affecting the making or operation of any law. I. So far as it provides for the orderly marketing or production or growth or extraction of any agricultural product or mineral or any article or thing, prepared for market or manufactured therefore, or for the reasonable restriction of the use of any property in the interest of safeguarding the interests of others, or the protection of tenants, licensees, or others having rights in or over such property. Key. So far as it provides for the making of contributions compulsorily by workers to any industrial scheme or workers' organization intended to work or provide for the benefit or welfare of such workers, or of their fellow workers, or of any relatives and dependents of any of them. so far as it provides for the regulation of wages, that is, any money or other thing had or contracted to be paid, delivered, or given as recompense, reward, or remuneration for any work, labor, or service done or to be done, whether such provision is made prospectively or retrospectively, including retrospectively with effect from a day earlier than the day fixed for the coming into operation of this Constitution, or 2. For the compulsory taking of possession in the public interest of any property, or the compulsory acquisition in the public interest of any interest in or right over property, where that property, interest, or right is held by a body corporate established directly by law for public purposes, in which monies provided by Parliament or by any legislature previously established for the territory of Guyana have been invested. 4. In paragraph 3 III, regulation includes fixation, stabilization, freezing, or reduction. B. Wages includes merit increment or other increment in wages. Protection against arbitrary search or entry. 143. 1. Except with his or her own consent, no person shall be subjected to the search of his or her person or his or her property or the entry by others on his or her premises. 2. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article, to the extent that the law in question makes provision. A. That is reasonably required in the interests of defense, public safety, public order, public morality, public health, town or country planning, the development or utilization of mineral resources, or the development or utilization of any other property in such manner as to promote the public benefit. B. That is reasonably required for the purpose of protecting the rights or freedoms of other persons. C. That authorizes an officer or agent of the government of Guyana, or of a local democratic organ, or of a body corporate established, directly by law, for public purposes, to enter on the premises of any person in order to inspect those premises, or anything thereon, for the purpose of any tax, duty, rate, cess, or other impost, or in order to carry out work connected with any property that is lawfully on those premises, and that belongs to that government, local democratic organ, or body corporate, as the case may be, or for the purpose of obtaining or verifying information required for compiling national statistics, or required for the purposes of planning, management, and development of the national economy, or provisions to secure protection of law. D. That authorizes, for the purpose of enforcing the judgment or order of a court in any proceedings, the entry upon any premises, by order of a court. 144. 1. If any person is charged with a criminal offense, then, unless the charge is withdrawn, the case shall be afforded a fair hearing, within a reasonable time, by an independent and impartial court established by law. 2. It shall be the duty of a court to ascertain the truth in every case, provided that every person who is charged with a criminal offense, A. shall be presumed to be innocent until he or she is proved or has pleaded guilty. B. Shall be informed as soon as reasonably practicable, in a language that he or she understands and in detail, of the nature of the offense charged. C. Shall be given adequate time and facilities for the preparation of his or her defense. D. Shall be permitted to defend himself or herself before the court in person, or by a legal representative of his or her own choice. E. Shall be afforded facilities to examine in person, or by his or her legal representative, the witnesses called by the prosecution before the court, and to obtain the attendance and carry out the examination of witnesses to testify on his or her behalf before the court, on the same conditions as those applying to witnesses called by the prosecution. And F. Shall be permitted to have without payment the assistance of an interpreter if he or she cannot understand the language used at the trial of the charge. And except with his or her consent, the trial shall not take place in his or her absence, unless he or she so conducts himself or herself as to render the continuance of the proceedings, in his or her presence, impracticable, and the court has ordered him or her to be removed, and the trial to proceed in his or her absence, or he or she fails without reasonable excuse, the proof whereof shall lie on him or her, to attend court. 3. When a person is tried for any criminal offense, the accused person or any person authorized by him or her in that behalf shall, if he or she so requires and subject to payment of such reasonable fee as may be prescribed by law, be given within a reasonable time after judgment a copy for the use of the accused person of any record of the proceedings made by or on behalf of the court. 4. No person shall be held to be guilty of a criminal offense on account of any act or omission that did not at the time it took place constitute such an offense, and no penalty shall be imposed for any criminal offense that is more severe in degree or nature than the most severe penalty that might have been imposed for that offense at the time when it was committed. 5. No person who shows that he or she has been tried by a competent court for a criminal offense and either convicted or acquitted shall again be tried for that offense, or for any other criminal offense of which he or she could have been convicted at the trial for that offense, save upon the order of a superior court in the course of appeal proceedings relating to the conviction or acquittal. 6. No person shall be tried for a criminal offense if he or she shows that he or she has been granted a pardon for that offense. 7. No person who is tried for a criminal offense shall be compelled to give evidence at the trial. 8. Any court or other tribunal prescribed by law for the determination of the existence or extent of any civil right or obligation shall be established by law, and shall be independent and impartial, and where proceedings for such a determination are instituted by any person before such a court or other tribunal, the case shall be given a fair hearing within a reasonable time. 9. Except with the agreement of all the parties thereto, all proceedings of every court and proceedings for the determination of the existence or extent of any civil right or obligation before any other tribunal, including the announcement of the decision of the court or other tribunal, shall be held in public. 10. Nothing in the preceding paragraph shall prevent the court or other tribunal from excluding from the proceedings persons other than the parties thereto, and their legal representatives, to such extent as the court or other tribunal a. may by law be empowered so to do, and may consider necessary or expedient in circumstances where publicity would prejudice the interests of justice, or interlocutory proceedings, or in the interests of decency, public morality, the welfare of persons under the age of 18 years or the protection of the private lives of persons concerned in the proceedings, or b. may by law be empowered or required so to do in the interests of defense, public safety, or public order. 11. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of a. Paragraph 2a. To the extent that the law in question imposes upon any person charged with a criminal offense the burden of proving particular facts. b. Paragraph 2e. To the extent that the law in question imposes conditions that must be satisfied if witnesses called to testify on behalf of an accused person are to be paid their expenses out of public funds. Or c. The paragraph 5. To the extent the law in question authorizes a court to try a member of a disciplined force for a criminal offense notwithstanding any trial and conviction or acquittal of that member under the disciplinary law of that force. So, however, that any court so trying such a member and convicting him or her shall, in sentencing him or her to any punishment, take into account any punishment awarded him or her under that disciplinary law. 12. In the case of any person who is held in lawful detention, the provisions of paragraph 1, paragraph 2, d and e and paragraph 3 shall not apply in relation to his or her trial for a criminal offense under the law regulating the discipline of persons held in such detention. 13. Nothing contained in paragraph 2d shall be construed as entitling a person to legal representation at public expense, but, subject thereto, it shall be the duty of the state to ensure every person charged with a criminal offense is given a fair trial and accordingly to make provisions for legal aid to be given in suitable cases. 14. In this article, criminal offense means a criminal offense under the protection of freedom of conscience. 145. 1. Except with his or her own consent, no person shall be hindered in the enjoyment of his or her freedom of conscience, and for the purposes of this article the said freedom includes freedom of thought and of religion, freedom to change his or her religion or belief, and freedom, either alone or in community with others, and both in public and in private, to manifest and propagate his or her religion or belief in worship, teaching, practice, and observance. 2. No religious community shall be prevented from providing religious instruction for persons of that community. 3. Except with his or her own consent, or if he or she is a person who has not attained the age of 18 years, the consent of his or her legal guardian, no person attending any place of education shall be required to receive religious instruction, or to take part in, or attend any religious ceremony or observance if that instruction, ceremony, or observance relates to a religion which is not his or her own. 4. No person shall be compelled to take any oath which is contrary to his or her religion or belief, or to take any oath in a manner which is contrary to his or her religion or belief. 5. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article to the extent that the law in question makes provision a. which is reasonably required, I. in the interests of defense, public safety, public order, public morality, or public health, or t. for the purpose of protecting the rights and freedoms of other persons, including the right to observe and practice any religion, without the unsolicited intervention of members of any other religion, or protection of freedom of expression. 6 of 2001. B. With respect to standards, or qualifications to be required in relation to places of education including any instruction, not being religious instruction given at such places. X. References in this article to a religion shall be construed as including references to a religious denomination, and cognate expressions shall be construed accordingly. 146. 1. Except with his or her own consent, no person shall be hindered in the enjoyment of his or her freedom of expression, that is to say, freedom to hold opinions without interference, freedom to receive ideas and information without interference, freedom to communicate ideas and information without interference, and freedom from interference with his or her correspondence. 2. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article to the extent that the law in question makes provision a. that is reasonably required in the interests of defense, public safety, public order, public morality, or public health, b. that is reasonably required for the purpose of protecting the reputations, rights and freedoms of other persons, or the private lives of persons concerned in legal proceedings, preventing the disclosure of information received in confidence, maintaining the authority and independence of the courts, regulating the technical administration or the technical operation of telephony, telegraphy, posts, wireless broadcasting, or television, or ensuring fairness and balance in the dissemination of information to the public, or c. that imposes restrictions upon public officers or officers of any corporate body established on behalf of the public or owned by or on behalf of the government of Guyana. D. that imposes restrictions upon any person, institution, body, authority, or political party from taking any action or advancing, disseminating, or supporting any idea, which may result in racial or ethnic divisions among the people of Guyana. 3. Freedom of expression in this article does not relate to hate speeches or other expressions, in whatever form, capable of exciting hostility or ill will, against any person or class of persons. Protection of freedom of assembly, association and demonstration. 10 of 2003, 147, 1. Except with his or her own consent, no person shall be hindered in the enjoyment of his or her freedom of assembly, association and freedom to demonstrate peacefully, that to say, his or her right to assemble freely, to demonstrate peacefully and to associate with other persons and in particular to form or belong to political parties, trade unions or other associations for the protection of his or her interests. 2. Except with his or her own consent, no person shall be hindered in the enjoyment of his or her freedom to strike. 3. Neither an employer nor a trade union shall be deprived of the right to enter into collective arguments. 4. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article, to the extent that the law in question makes provision a. that is reasonably required in the interests of defense, public safety, public order, public morality, or public health. B. that is reasonably required for the purpose of protecting the rights or freedoms of other persons. C. that imposes restrictions upon public officers, or D. that imposes an obligation on workers to become contributors to any industrial scheme or workers' organization intended to operate or provide for the benefit or welfare of such workers, or of their fellow workers, or of any relative and of any of them. Protection of freedom of movement. 148. 1. No person shall be deprived of his or her freedom of movement, that is to say, the right to move freely throughout Guyana, the right to reside in any part of Guyana, the right to enter Guyana, the right to leave Guyana, and immunity from expulsion from Guyana. 2. Any restriction on a person's freedom of movement that is involved in his or her lawful detention shall not be held to be inconsistent with or in contravention of this article. 3. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article, to the extent that the law in question makes provision a. for the imposition of restrictions on the movement or residence within Guyana of any person or on any person's right to leave Guyana, that are reasonably required in the interests of defense, public safety or public order, or for the purpose of preventing the subversion of democratic institutions in Guyana. B. For the imposition of restrictions on the movement or residence within Guyana, or on the right to leave Guyana of persons generally, or any class of persons that are reasonably required in the interests of defense, public safety, public order, public morality, or public health, or for the purpose of preventing the subversion of democratic institutions in Guyana. C. For the imposition of restrictions on the acquisition or use of land or other property in Guyana. D. For the imposition of restrictions by order of a court on the movement or residence within Guyana of any person or on any person's right to leave Guyana, either in consequence of his or her having been found guilty of a criminal offense under the law of Guyana, or for the purpose of ensuring that he or she appears before a court at a later date for trial for such a criminal offense, or for proceedings preliminary to trial, or for proceedings relating to his or her extradition or lawful removal from Guyana. E. For the imposition of restrictions on the freedom of movement of persons who are not citizens of Guyana. F. For the imposition of restrictions upon the movement or residence within Guyana or on the right to leave Guyana of public officers. G. For the removal of persons from Guyana to be tried or punished in some other country for a criminal offense under the law of that country, or 2. To undergo imprisonment in some other country in execution of the sentence of a court in respect of a criminal offense under the law of Guyana of which he or she has been convicted, or to be detained in an institution in some other country for the purpose of giving effect to the order of a court made in pursuance of a law of Guyana relating to the treatment of offenders under a specified age, or IV. To be detained for care or treatment in a hospital or other institution in pursuance of a law of Guyana relating to persons suffering from defect or disease of the mind, or H. For the imposition of restrictions on the right of any person to leave Guyana that are reasonably required in order to secure the fulfillment of any obligations imposed on that person by law. 4. The provisions of Article 151 shall apply in relation to a person whose freedom of movement is restricted by virtue of such a provision, as is referred to in paragraph 3a, as they apply in relation to a person, protection from discrimination on the grounds of race, etc. 10 of 2003, whose freedom of movement is restricted by virtue of such a provision, as is referred to in Article 152. 149. 1. subject to the provisions of this article. A. No law shall make any provision that is discriminatory either of itself or in its effect, and b. No person shall be treated in a discriminatory manner by any person acting by virtue of any written law or in the performance of the functions of any public office or any public authority. 2. In this article, the expression discriminatory means affording different treatment to different persons attributable wholly or mainly to their or their parents or guardians, respective descriptions by race, place of origin, political opinion, color, creed, age, disability, marital status, sex, gender, language, birth, social class, pregnancy, religion, conscience, belief or culture, whereby persons of one such description are subjected to disabilities or restrictions to which other persons of the same or another such description are not made subject, or are accorded privileges or advantages which are not afforded to other persons of the same or another such description. 3. Paragraph 1, A shall not apply to any law so far as that law makes provision, A. with respect to persons who are not citizens of Guyana, B. with respect to adoption, marriage, divorce, burial, devolution of property on death or other matters of personal law, or C. whereby persons of any such description as is mentioned in the preceding paragraph may be subjected to any disability or restriction, or may be accorded any privilege or advantage which, having regard to its nature, and to special circumstances pertaining to those persons, or to persons of any other such description, is reasonably justifiable. 4. Nothing contained in any law shall be held to be inconsistent with or in contravention of paragraph 1a, to the extent that it makes provision with respect to standards or qualifications not being standards or qualifications specifically relating to a person's or his or her parents' or guardians' respective description by race, place of origin, political opinions, color, creed, age, disability, marital status, sex, gender, language, birth, social class, pregnancy, religion, conscience, belief or culture, to be required of any person who is appointed to any office in the public service, any office in a disciplined force, or any office in the service of a local democratic organ, or of a body corporate established by any law for public purposes. 5. Paragraph 1b shall not apply to anything which is expressly or by necessary implication authorized to be done by any such provision of law as is referred to in either of the two preceding paragraphs. 6. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article, to the extent that the law in question makes provision, a. whereby persons of any such description as is mentioned in paragraph 2 may be subjected to any restriction on the rights and freedoms guaranteed by Articles 143, 145, 146, 147 and 148, being such a restriction as is authorized by Article 143(2), Article 145(5), Article 146(2), Article 147(2), or Article 148(3), other than subparagraph C thereof, as the case may be, b. for the appropriation of revenue or other funds of Guyana, or c. for the protection, well-being or advancement of the Amerindians of Guyana. 7. Paragraph 1b shall not affect any discretion relating to the institution, conduct or discontinuance of civil or criminal proceedings in any court that is vested in any person by or under this Constitution or any other law. Right to work 10 of 2003. 149a. No person shall be hindered in the enjoyment of his or her right to work, that is to say, the right to free choice of employment. Right to pension and gratuity. 10 of 2003. 149 billions. Every public sector worker shall enjoy an absolute and enforceable right to any pension or gratuity granted to him or her under the provision of any law or collective agreement of any kind whatsoever. Right to participate. 149c. No person shall be hindered in the enjoyment of participating through cooperatives, trade unions, civic, in decision-making processes of the state. 10 of 2003. Or socio-economic organizations of a national character, in the management and decision-making processes of the state. Equality of persons before the law. 10 of 2003. 149d1. The state shall not deny to any person equality before the law, or equal protection and benefit of the law. 2. The state shall, for the purpose of promoting equality, take legislative and other measures designed to protect disadvantaged persons and persons with disabilities. 3. Equality includes the full and equal enjoyment of all rights and freedoms guaranteed by or under this Constitution or any other law. Equality of status 10 of 2003. 149e1. All persons, whether born in or out of wedlock, and whether born prior to the enactment of this article or not, are born equal, have equal status and are entitled to equal rights. Equality for women. 10 of 2003. 2. Nothing contained in paragraph 1 shall be taken to affect vested rights. 149, F1. Every woman is entitled to equal rights and status with men in all spheres of political, economic and social life. All forms of discrimination against women on the basis of gender or sex are illegal. 2. Every woman is entitled to equal access with men to academic, vocational and professional training, equal opportunities in employment, remuneration and promotion, and in social, political and cultural activity. Indigenous people's right. 10 of 2003, 149 grams. Indigenous peoples shall have the right to the protection, preservation, and promulgation of their languages, cultural heritage and way of life. Right to free education. 10 of 2003, 149 hours. 1. Every child is entitled to free primary and secondary education in schools owned or funded by the state. 2. The right conferred in paragraph 1 does not imply a right to free education at a specific school. 3. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of paragraph 1. To the extent that the law in question makes provision for standards or qualifications not being standards or qualifications which are discriminatory within the meaning of Article 149(2), to be required for admission to a specific school. Right to establish private schools. 10 of 2003, 149. No person shall be hindered in the enjoyment of the right to establish a private school, which shall be under regulation by the state. The environment. 10 of 2003, 149J. 1. Everyone has the right to an environment that is not harmful to his or her health or well-being. 2. The state shall protect the environment, for the benefit of present and future generations, through reasonable legislative and other measures designed to a. Prevent pollution and ecological degradation, b. Promote conservation and c. Secure sustainable development and use of natural resources while promoting justifiable economic and social development. 3. It shall not be an infringement of a person's rights under paragraph 1, if by reason only of an allergic condition or other peculiarity, the environment is harmful to that person's health or well-being. Provisions for time or war or emergency. 150. 1. This article applies to any period when a. Guyana is at war or b. There is in force a proclamation in this article referred to as a proclamation of emergency made by the President declaring that a state of public emergency exists for the purposes of this article, or c. There is in force a resolution of the National Assembly, in favor of which there were cast the votes of not fewer than 2/3 of all the elected members, declaring that democratic institutions in Guyana are threatened by subversion. 2. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of Article 139, 142, or 143. Any provision of Article 144, other than paragraph 4 thereof, or any provision of Articles 145 to 149 inclusive, to the extent that the law in question makes in relation to any period to which this article applies provision, or authorizes the doing during any such period of anything, which is reasonably justifiable in the circumstances of any situation arising or existing during that period for the purpose of dealing with that situation. 3. Where any proclamation of emergency has been made, copies thereof shall as soon as practicable be laid before the National Assembly, and if, by reason of its adjournment, or the prorogation of Parliament, the Assembly is not due to meet within 5 days, the President shall by proclamation summon the Assembly to meet within 5 days, and the Assembly shall accordingly meet and sit upon the day appointed by the proclamation, and shall continue to sit and act as if it had stood adjourned, or Parliament had stood prorogued to that day. b. A proclamation of emergency shall, unless it is sooner revoked by the President, cease to be in force at the expiration of a period of 14 days beginning on the date on which it was made, or such longer period as may be provided under the next following subparagraph, but without prejudice to the making of another proclamation of emergency at or before the end of that period. If at any time while a proclamation of emergency is in force, including any time while it is in force by virtue of the provisions of this subparagraph, a resolution is passed by the Assembly approving its continuance in force for a further period not exceeding 6 months, beginning on the date on which it would otherwise expire, the proclamation shall, if not sooner revoked, continue in force for that further period. 4. A resolution such as is referred to in paragraph 1 key shall, unless it is sooner revoked by a resolution of the Assembly, cease to be in force at the expiration of 2 years beginning on the date on which it was passed, or such shorter period as may be specified therein, but without prejudice to the passing of another resolution by the Assembly in the manner prescribed by that paragraph at or before the end of that period. Reference to tribunal in certain cases. 151. Where any person is lawfully detained by virtue of such a provision as is referred to in Article 152, or the movement or residence within Guyana of any person or any person's right to leave Guyana, is otherwise than by order of a court, lawfully restricted by virtue of such a provision as aforesaid, his or her case shall be reviewed by a tribunal established for the purposes of this article not later than 3 months from the commencement of the detention or restriction, and thereafter not later than 6 months from the date on which his or her case was last reviewed as aforesaid. 2. On any review by a tribunal in pursuance of the preceding paragraph of the case of any person, the tribunal may make recommendations concerning the necessity or expedience of continuing the detention or restriction to the authority by whom it was ordered, but, unless it is otherwise provided by law, that authority shall not be obliged to act in accordance with any such recommendation. 3. A tribunal established for the purpose of this article shall be so established by law, and constituted in such manner as to secure its independence and impartiality, and presided over by a person appointed by the Chancellor from among persons entitled to practice in Guyana as attorneys at law. Saving of existing laws and disciplinary laws. 152. 1. Except in proceedings commenced before the expiration of a period of 6 months from the commencement of this Constitution, with respect to a law made under the Guyana Independence Order 1966 and the Constitution annexed thereto, nothing contained in or done under the authority of any written law shall be held to be inconsistent with or in contravention of any provision of Articles 138 to 149 inclusive, to the extent that the law in question A is a law in this article referred to as an existing law, that had effect as part of the law of Guyana immediately before the commencement of this Constitution, and has continued to have effect as part of the law of Guyana at all times since that day. B. Repeals and reenacts an existing law without alteration, or C. Alters an existing law and does not thereby render that law inconsistent with any provision of the said Articles 138 to 149, in a manner in which, or to an extent to which, it was not previously so inconsistent. 2. In subparagraph C of the preceding,